Before we get to today's episode of 80 More Things, I just wanted to pop in here with a quick disclaimer. The purpose of this podcast is to give people in the community a place to express their opinions and their voice. I just want to be clear that the opinions of our guests are theirs and that Julie and I may or may not agree with their point of view. With that, let's get started.
I could go on listing things off, 80 more things. I just keep on singing these songs till Avery's freedom rings. I said it matters. It really does. I know it matters. This could be you. I said it matters. This could be me. I said it matters.
Welcome to 80 More Things, where we go beyond making a murderer and discuss questionable details of the Teresa Halbach murder case. My name is Fen. You can find me on Twitter at FenMN. The song you just heard a piece of is called It Really Matters by Stacy Seabrook. Stacy is reminding us that Stephen Avery believes that the key to his eventual exoneration is for all of us to keep talking about this case. So that is what we intend to do. Not only for Steven and Brendan, but also in the hopes that there will someday be actual justice for Teresa Halbach. If you somehow find yourself here, but you haven't yet watched the Netflix series Making a Murderer, stop listening to this podcast right now and go watch both seasons before joining us here, or a lot of this won't really make any sense to you. As always, joining me on 80 More Things is my co-host, Julie Pom Pom. You can find Julie on Twitter at JujuPomPom. Hello, Julie.
Hi, Fen. How are you today?
I'm really excited about our guest today.
Oh, me too. I've been excited about this one for a while.
Today, we're going to be talking about day 35 of the 80 days of 80 More Things, and I'll get to what that is in a minute. But first, I want to introduce our guest, Travis Williamson. Travis has been an attorney for over 30 years, so he knows a thing or two. He's exclusively a defense attorney, having never worked for a prosecuting agency, and he focuses primarily on criminal defense. He's represented many medical professionals, and that has required in-depth study and research of science and medicine, so he's got a great deal of expertise in those areas. He's been interested in the Halbach case for quite some time, and we're really pleased to welcome Travis Williamson to 80 More Things.
Thank you for having me. I'm excited to be here.
So before we get to day 35, as a lawyer, you must be interested in all kinds of cases, but you've been invested kind of in this case for quite a while. So what is it about the Halbach case that you found so compelling that you're willing to keep talking about it?
I had several friends, including a really good friend of mine, a dentist in Louisiana, that started calling me about first the documentary, and then I watched all of that, and then he had continued questions about the legal aspects of it, what the current state of the legal proceedings were. And so I ended up, in trying to answer his questions and other friends' questions about it, I ended up reading all of the documents in the case back when MAM1 came out. And like a lot of people in the process of doing that, I became intrigued about several aspects of the case, and we can kind of talk about those as we go along. But it was mainly to help friends understand the legal process, and specifically the post-conviction legal process.
Well, I know that's why we like to talk to you, to help us understand the legal aspects of this case. And one of the big legal discussions that has been had over the past year, since we found out the disposition of the bones in this case. So let me just read day 35 of 80 Days of 80 More Things. So day 35 reads, if the bones found in the quarry were not Teresa's, why did the state give them to the Halbach family as if they were? So I'd like to talk about that. I'd like to talk about the bones, how they were given to the Halbachs, whether they were Teresa's or not Teresa's, what Kathleen is arguing about those bones and what the state is arguing about the bones, and kind of just your opinion on that subject.
Good.
So I guess we'll start with this. We start at the beginning with the bones. In Stephen's trial, The bones that were found in his burn pit, were those ever proven to be Teresa Halbach's bones?
One bone was proven to be a partial match. The significance of a partial DNA match is very much debated. How much is there? Because the FBI is on mitochondrial DNA testing, and I'm not an expert in that. There's other people that have talked about that in the various groups that we belong to that have much more knowledge about that than myself, Scooby being one, and she pointed out a lot of this stuff. But I believe there was nine alleles that lined up, and the FBI keeps on bumping up the number. So that was, for most agencies, that would not be enough to be a conclusive match. It's called a partial match. And the significance of it forensically is most jurisdictions would not allow that into evidence on that one particular bone. The rest of the bones, to my knowledge, the type of testing they've done up to this point, they've never been tested because they were looked at by the FBI, and the FBI on visual examination concluded that they were too burned, too degraded in order for there to be any significant testing. So they didn't test them.
So regardless of whether they were proven to be Teresa's or not, those bones found in his burn pit were used to convict Steven Avery.
Yes, quite extensively. I mean, it was a huge issue in Steven Avery's case. We're all familiar with, in closing argument, Ken Kratz's statement, "I'm not going to spend more than 20 seconds on those bones," referring to the bones that were over in what was referred to as the Redonk gravel pit, the quarry, later determined to be the county's gravel pit. But he says, "I'm not going to spend more than 20 seconds on those bones." Whereas the defense spent, and they did have experts on this, to determine there was more than one burn site. Their position was that the initial burn site was somewhere else, and that it was probably in the quarry, and therefore those bones were disposed of in one of the burn barrels where they found bones and the burn pit.
So what Kathleen wanted to do is she wanted to test the bones that were found, specifically the bones found in what was referred to as the Redonk gravel pit or the quarry. She wanted to test those bones, and the state told her, "Sure, you can test those bones." And then we discovered about a year ago that they in fact had given those bones, along with bones from Steven Avery's burn pit, to the Halbach family in 2011. So when they promised her the ability to test these bones, and she's got they've got some new rapid DNA testing they can do that has been very accurate, but they're confident they can discover whether these were Teresa's bones or not. So at the time that they promised her that they could do this, they knew full well that they didn't have them in their possession.
Yeah, so that's how I got into it and why I was really interested in day 35 and this particular thing that, there's at least 80 of. So like I said, I first became aware and involved in the case trying to answer questions for friends. And then after MAM2, I ran into, just on a fluke, I was looking around YouTube to see if there was anybody that was talking about it that was reliable and credible and mainstream. And I ran across a few, and then for a variety of reasons, I really latched on to Erekose's YouTube site. One, he seemed to be very, very knowledgeable about the evidence in the case and what wasn't evidence, what was evidence, what's available, what's reliable. And then he had a lot of people such as you and Julie and Allie and other people that were aware of what was factual, what was evidence in the case, what was contained in the documents that were available. And I had read all of those documents, but I can't remember how much space and time there was between number one and number two, but you just cannot remember all of the stuff. And so I was looking for a YouTube channel that where people were knowledgeable. So, and I got involved in that in November after MAM2 came out. So that last year, a little over a year ago. And then I noticed in his channel, people were asking questions. They were for the first time going through the documents. And one of the things they were going through was queso. And specifically Adrienne, and her nickname, we go by AG. And she had found something related to one of the bullets, item FL, as it related to the gun that they took out of the trailer and the item number on that. And it appeared, and this ended up being one of the early 80 things, was that the report on item FL indicated that the bullet was found at a time that just wasn't possible. They claimed that that was found in the latter search after Brendan's confession and that it matched up with the gun. In the report, they said they found that bullet in November, 4 or 5 months earlier. So that's just impossible. And so that at first blush looked like, oh my gosh, here's a clear plant of evidence. Here's something that for sure we can demonstrate is not true. I dug into that and was helping Adrienne get into that. And then what I decided to do is I wanted to, Adrienne and other people, when they were talking about the case, they'd say, well, I'm not a lawyer and I'm not this and I'm not that. And what I wanted to show people is you don't have to be a lawyer to dig into this stuff. You just have to have an open mind and, you know, be logical and be objective. And you have to look at the actual documents. So as great as all of this information we have on YouTube and Reddit and like your podcasts and whatnot, I wanted to educate people on how they can go about checking these things on their own, even though they don't have a law degree, even though they don't have a degree in chemistry or forensic anthropology. You don't have to have that. You just have to be willing to learn and educate yourself about it and understand that you can't rely on somebody else. You really need to look at it for yourself, understand the evidence, and then as you do that, you kind of figure out what people are credible and what people are knowledgeable and who you can trust and whatnot. So we went through that exercise, going through queso and analyzing that. And as part of that, I became familiar with the numbers of these bones. So they're all numbered. They have 4-digit numbers like 68, 75, and so on and so forth. At the same time, I ran into and met Allie, and Allie was doing at that time a lot of videos, and specifically she was doing a lot of videos on bones. And so I got to be familiar with the numbers of these different bones and whatnot. That's in the November timeframe. And then Erekose started asking me to discuss topics of a legal nature on his channel. And then we fast forward to December 18th. That's about the time that the brief was supposed to be due. And then she filed first a motion for new scientific testing, which included the rapid DNA testing. And she asked for those bones. And so I'm looking through there, and specifically why she wanted to do that is the big fire out in California the fall before. So we're November of last year, and there had been a huge, terrible
fire.
Yes, and a lot of people perished. Their bodies and their bones burned in that conflagration. And the expert she wanted to use had developed this rapid DNA testing process, and he was able to successfully identify a lot of people from their cremains on bones that would have been previously thought too degraded. We're not going to be able to do anything with this. Zellner got a hold of him, showed him photographs of the bones by number, and said, hey, can you do anything with this? And he said, yeah, I can. I think I can test, and we're going to get enough information back. I can identify about 80% of them. And so these bones that she wanted tested are the ones we talked about earlier that were disputed. Eisenberg the state's expert had categorized many of these bones as possibly human. One was identified as a pelvic bone. I believe that's 8675. That was a big issue in the case. A lot of argument over that during the trial, which is important to remember. And so her motion came up, and Allie had gotten that to me at about 7 a.m, and I started going through it. Erekose wanted to do a video on the motion for scientific testing. So she wanted to, instead of filing her brief, she filed a request to the court saying, I want you to extend the time for me to file a brief because there's this new scientific testing. And Erekose wanted me to explain that to his viewers, what the legal significance of that motion was. So as I was going through that, I saw all of these numbers. I said, why do I know those numbers? And so I went to Queso and I set it up into a searchable PDF, and I entered the number and returned to the Halbach family. And then I entered another number that the expert wanted, returned to Halbach family. So I called Erekose up and I said, look, this thing is hugely significant, but not for the reasons a lot of people are thinking. It appears to me that 90% of the bones that Zellner's expert is asking for to test have been given away. And this has huge legal ramifications under the doctrine of spoliation. And it has constitutional implications, which that can get you a new trial. And I said, I've got a bunch of stuff going on during the day. What I would like to do is, because, you know, it's not that Erekose or anybody else in what eventually became named as the Wrecking Crew is like super secretive, or they pretty much share everything with the community, but you want to fact check this stuff before you put it out. And we've seen examples of that, people putting stuff out and then it turns out it's based on a false assumption. And so again, going back, I wanted to educate people how to legitimately research items and be credible about it. And so I said, you know, what I'd like to do is involve a few of these other people we've been talking with offline through different formats and involve them in helping me research this during the day, if that's okay with you. And he said, yeah, absolutely. So I got a hold of Julie, and I got a hold of another person named Lucy Help. Basically, I handed out 3 or 4 assignments: location of the bones by GPS coordinates, wanted to know if Wisconsin had an evidence preservation statute. I asked Allie specifically, her job was, I got her the numbers and I asked her to double check me. And this is done in journalism all the time. Magazines have and newspapers have what they call fact checkers. And good ones go back and verify everything with the source. And we do that in law also. And so I wanted Allie to please check my numbers and see if I'm correct on this. And then we had GPS coordinates for the first time, and that was complicated. So I just gave you, Julie, the coordinates or the document reference for the coordinates and asked you to work on seeing if you could locate where the number of bone piles and where they were in the quarry. You did that and produced maps about it. Anyway, the point of all of this was that I gave people a few different assignments, and then on the 18th, I believe it was, or it may have been the 19th of last year, exactly a year ago, we did this video where I went through the motion section by section. But at the outset, we said, you know, we've got jaw-dropping, groundbreaking information that's not even part of this motion. And then we revealed that as a team, we were able to determine that the bones were given back to the Halbach family. And then I explained the legal significance of that was spoliation and a violation of the evidence preservation statute in Wisconsin, and that would have could potentially have huge legal significance.
Before you continue, let's
Mhm.
talk for a second about the evidence preservation statute in Wisconsin. It's my understanding that the preservation statute in Wisconsin is only relevant if the biological material belongs to the victim.
There's three parts, and I don't have it in front of me, and that is one part. The biological evidence belonged to the victim, and then it would have significance. But there's another part that unfortunately is not very clear, which I argued at the time, and I still argue has significance, because if you think about how do people get exonerated, they typically get exonerated because they find blood or evidence at a location that has the real perpetrator's DNA. That happened in Steven's first wrongful conviction. They found DNA under the victim's fingernails that unfortunately didn't positively exclude him. Then they found hair, which came back to the perpetrator, and that's what ultimately got him free. And so it was my argument that, yeah, you do need to maintain evidence that you think belongs to the victim, but you really need to maintain, under the first part of the statute, everything that's potentially biological, whether it comes back as the victim or another suspect. Because if you throw away DNA that could potentially come back to another suspect, and you're not required under the preservation statute, there's really no significance to the preservation statute. I mean, what good is it? What good would it have been that they had, and the statute was not in place in Steven's first case. Fortunately, they just hung on to it. And the Innocence Project of Wisconsin had access to do that, thankfully. But under the statute, if it's a pubic hair, well, they know that's not the victim. That's not biological evidence of the victim. And they said, oh, well, we don't have to preserve that. What good's the statute that threw away that pubic hair and weren't able to test that? It would be a meaningless evidence preservation statute.
So
that was my argument. But there's three parts to that statute. One part clearly does require maintain evidence of the victim. Yes, it does.
So maybe I'm getting ahead of myself here, but let me ask you this. How does that relate to their argument that it doesn't apply because it wasn't proven to be the victim?
So it relates because, one, as I mentioned earlier, when I said keep this in mind, that it was a central issue in the case, why that's important is it was a hotly contested issue, these bones, specifically the pelvic bone. And Eisenberg, the state's expert, was cross-examined on the pelvic bone and other bones, and that, hey, these are probably human, and they're probably over in the quarry. And what Zellner brought out is that not only were they in the quarry, she brought out, before any of this stuff came out in December of last year, she brought out in the pleadings and testing she had done up to that time, she had established 3 bone piles in the quarry. And that didn't make a whole lot of sense, that you had bones in 2 locations. And that one of the central points of contention between the defense and the state in the trial was where was the primary or initial burn location? Defense said it was over in the quarry, and then somebody planted the bones in Steven's yard. The state said, no, it was the burn pit. He tried to get up all of the bones, but he couldn't, and he planted them. Now, this made no sense. He planted them, some in his sister's burn barrel, and then took them. They could not concede that there were bones in the quarry, because that would make no sense for him to go clean out his burn pile, take them over to the quarry and pour them out there. why would he put them in Barbara's burn barrel? So that's why he didn't want to spend Kratz more than 20 seconds on those bones being the bones in the quarry. So why it's significant is it all goes to undermining the confidence of the verdict in Steven's original case. So specifically, really what you want to do is you want to show under Youngblood that the bones were destroyed, the evidence was destroyed in bad faith, and that the evidence would be material. And there's no question this evidence would be material based on what we just talked about. It would show for sure those are human bones over there. And then that's what you want, because if you have a constitutional violation, you get a new trial. So what are other constitutional violations? Brady, you're not given exculpatory evidence that you were entitled to receive. You were not given effective assistance of counsel. Those are constitutional violations, which if you're able to show and you meet all the requirements, you get a new trial. Same under Youngblood. If the state destroyed evidence that was material and in bad faith, that they knew that this information was important and they got rid of it, not by mistake or inadvertent, something like that, that's a constitutional violation. Then some states have an evidence preservation statute which goes even beyond Youngblood, that, and this all came out with DNA testing and whatnot. We saw exonerations. We had exonerations of people on death row. That shook up a lot of states, and they said, yeah, legislatures said, you need to preserve this stuff. Now, unfortunately, in Wisconsin, like many other states, most states have a remedy. If they destroy the evidence in violation of the state statute, there's a remedy. And that remedy could be that the case gets dismissed as a sanction against the state. It could be that the state can retry it, but the defendant is entitled to a specific jury instruction talking about how the evidence was destroyed by the state. In Wisconsin, there's no remedy in the statute. So it's a case of first impression in Wisconsin. No case has ever gone to any court of appeals in the state of Wisconsin, and therefore by definition, nor to the Wisconsin Supreme Court, involving a violation of the evidence preservation statute. So it is fertile ground, and we're going to need one or both of those courts to explain what the remedy would be if you violate the statute.
We're talking with Travis Williamson. The state argued that they didn't violate the statute, and the circuit court agreed with that. Where does it go from here?
Well, so going back to just that specific item, what you said, I don't think there's any way that the circuit court could have made that determination without conducting an evidentiary hearing in the circuit court. And that would have included having Norm Gahn and Fallon went to the evidence locker, and they put in queso that we collected the bones that, were determined by Eisenberg to be human, and sent those to a funeral home that the Halbach family had used in the past. We don't have any of the details about that. We're making a lot of assumptions about all of that, but the evidentiary hearing would have pinned all of that down. They'd have the evidence person there. They'd have Fallon and Gahn. Well, did you go through it? How did you determine? Which report are you talking about? Wait, what, why did you use her report at the trial? Your position was, even though her report says they were human, you argued to the jury they weren't Teresa's. And then you get to these questions you asked a little bit ago. Why are you giving bones to the Halbach family that you contended at trial were either not human or not Teresa's. You would want to, if you could, avoid calling anybody from the family, but if that wasn't possible, you'd want a representative of the family to testify at the evidentiary hearing. What were you told with regard to this receptacle of bones that you received? What were you told about them? And all of that would have been fleshed out. It would have all been under oath. Eisenberg could have been recalled as part of the evidentiary hearing, but it would have been established what was done, what was returned, and Zellner would have been able to ask, they would have been asked questions as they relate specifically to the evidence preservation statute. The evidence preservation statute says, yeah, you can do that, but you need to give notice to either the defendant or the defendant's attorney. And you're under an obligation to give that notice up until a certain amount of, in this case, it's easy. You're required to give that notice as long as they're in prison. And it relates to Brendan. Nobody got any notice, either side. The statute protects Brendan to the same extent as it does Steven. The evidence preservation statute does. Now, Youngblood, the constitutional violation, the fact that evidence got destroyed, for example, these bones, is not going to help Brendan as nearly as much, or if at all, because there wasn't any forensic evidence linking him to the crime. It's kind of like no harm, no foul. State's probably not going to give a don't shoot the messenger here, quote unquote, confessed murderer much of a break on a violation of the evidence preservation statute. It is positive if the lower court somehow comes around to finding a violation of the preservation statute. What's significant about it all goes back to your day 35 thing. Why are they contending now something completely different than they did at the time of trial?
So, Travis, you were saying that they have to meet these requirements, specific requirements, in order to get a new trial. And in order for Youngblood to apply, they have to show bad faith. And it can't be just, oh, something happened and the evidence was destroyed. It was an accident or something like this. They have to show that it was intentional. And you explained all the reasons why all of the things that support the claim that it was intentional. But yet the circuit court decided that no, it wasn't in bad faith, and the state in the document they filed says that the bones were inexplicably returned. So because they can attach that word to it, and the circuit court can say, no, it wasn't intentional, that makes it not intentional in the proceedings of the court, right? So basically the only thing, because we've talked about it before, that the law and logic are two different things. We can see what's really going on. We can see the facts of what's going on, but in order to make that apply, the court has to agree with it, right? Is that correct? Like, is this just a game of continuing to try doing it until they find a judge that will agree with it?
Well, no, because the appellate court can't do fact finding. The circuit court is supposed to hear testimony and determine facts, but they're not doing it. And so at this point, Zellner's asked for alternative things. I'd like A, but if not A, I'd like B, and if it's not B, I'd like C. And really the thrust of what she's asking for in her brief with the appellate court is evidentiary hearings on the constitutional issues, the ineffective assistance of counsel, the Brady violations, and now after the bones came to light, she's asking for an evidentiary hearing for the court to hear testimony and enter findings of fact on whether it was in bad faith, whether it's material. That's on the Youngblood case. And then also with respect to the items under the evidence preservation statute. So she would get the witnesses on in the evidentiary hearing, get testimony to show that she has satisfied all of the requirements of the evidence preservation statute and can show that it's violated. There's no fact findings on any of that at this point. The circuit court judge made a lot of assumptions, a lot of factual assumptions that logic does come into play, because you can look at what she would have had to have assumed for her to find the way she did in her circuit court opinion. Other circuit courts in that area get it, just not that particular one. Maybe it's going to take the Court of Appeals telling the circuit court that, no, you didn't listen to what we were asking for. We want findings of fact on these issues. We're sending it back to you.
Do you think that they will?
I think, of course, we don't, at the time of this recording, we don't have the state's response. You have hopefully lined up a good friend of mine as your guest to talk about that when it comes out.
We hope that too.
Yeah.
We'll see.
We'll see. We'll hope.
Yes, we do.
She has said, and I have said, I agree a lot, that there's only so much you can tell from Kathleen Zellner's appellate brief right now. You really need the state will have a response, and as much as people think that the arguments are well laid out, and they are, and they're well reasoned, and they are, and they're well supported, and they are, the state is going to have a response. But her brief is very well done. To get back to your question, she's asked, go ahead and reverse the conviction and find him innocent based on what we've got so far. That's a good thing she's asked that, because you just never know, but I think that's very doubtful. The alternative thing she's asked for is send this back to the circuit court for them to do a proper evidentiary hearing on all of the issues. And I think she'll get it on the bones. I think she'll get it on some or all of the Brady issues. And I think for sure she's going to get it on some or all of the ineffective assistance of counsel issues. And that's the right thing to happen. That's what happened in her Ferguson case that, is the subject of a recent documentary. And I think it's important for people to watch that if they haven't, just because it shows you how the logical process works. So if we can just go to that for 10 seconds, in Ferguson, had a young man that was convicted of being involved in a murder.
Let me just interject. We're talking about Ryan Ferguson, and the documentary is called Dream Killer, and it's on Netflix.
Yes, that's the documentary I'm referring to. And in that, you see that this young man's convicted of murder because his friend, or the person he was with at the time, confessed to murdering this individual, and that Ryan was there. Ryan said, I was never there. That never happened. I don't know what he's talking about, but he was convicted. And Zellner became involved in the case. Zellner then had an evidentiary hearing, and she called the prosecutor at the time, who is now a judge, and she called different people and got that testimony. And then their equivalent of the circuit court, the trial court judge, came up with this real ludicrous opinion based on faulty logic and misapplication of the law. And she was very vocal about it, said, this worst opinion I've ever seen, very critical of that circuit court judge. She went up to the appellate court, made her arguments. and they looked at it, and all of the facts were made by the lower court. So, well, here's the testimony. You can see that the circuit court just misapplied the facts, misapplied the law, and the appellate court looked at it and said, yeah, you're right. This young man should be out. That's how the process works. But the key point in looking at the Ryan Ferguson documentary is that she got her evidentiary hearing over several days, and she got that testimony on record to where she could argue it to an appellate court. And that is totally absent in Steven's case because the circuit court keeps denying an evidentiary hearing. And so, yes, I think it's very likely that the appellate court is going to look at these issues and say she's laid out enough to at least get an evidentiary hearing.
So I have a question for you, Travis. If and when Kathleen is granted the evidentiary hearing by the Court of Appeals, my understanding is that they are going to grant that request on specific issues. So when that evidentiary hearing takes place, is it limited to only discussing and resolving those specific issues? And is there anything in her brief that the Court of Appeals could use to grant her access to testing the RAV, or is that going to have to wait until a trial?
Both sides are stuck with the record that they have from the trial, and so no, they're not going to open up new testing of the RAV. The Court of Appeals will just apply it to those issues. Now, the Court of Appeals could say, yeah, we want an evidentiary hearing on issues 1, 5, 9, 12 and send it back. Or they can be more general about it and say, look, when we said we wanted a determination made and findings of fact, we really meant it. Go back and get this right. It could be that, and then everything's on the table. That would actually be better, because then if it goes back to the same circuit court judge, she's going to have to read that and interpret that there's an evidentiary hearing on every issue. Whereas if they just said issues 1, 3, 5, and 7, that's all she's going to hold a hearing on. But they could say also that we really think there is some sort of a conflict, and we're going to direct that it be reassigned.
You said that they're not going to open up new testing of the RAV, but in the order that was put in place about future testing of items in this particular case, there was a judge signed an order about that. And if I recall correctly, there was something in there that said that Steven would be able to test the blood DNA samples from the RAV in the future without having to obtain a court order for it. Am I wrong about that?
It was blood only, but it was unfortunately limited to what had already been obtained.
Right. Okay. So it's the swabs. It's not the actual blood drips that are in the RAV. It only applies to the swabs they apparently took from them. It only applies to the
samples. The way the order was written is that it only applies to the samples that are already in existence. It did not say they could go back and get more samples. You know, wasn't even an order that said you got to preserve the RAV, but they do need to preserve the RAV because it contains biological evidence.
Right.
And if they want to get rid of the RAV, they would have needed to send a letter to Brendan's and Steven's lawyers for as long as they remain in jail.
Yeah, well, they were supposed to do that with the bones too, and we see how well they did that. So just because they're supposed to do something doesn't mean they're gonna.
Right. So the Court of Appeals is not going to order new testing, but they could order, go back on an evidentiary hearing on this or that. During the course of an evidentiary hearing, Kathleen could establish that she could say, hey, we had an agreement to do this test of obtaining additional samples from the RAV. That would leave open the possibility that she could get the state, Fallon and Oregon, to agree to go forward with what they had previously agreed to. You follow what I'm saying? That if it was to swab certain parts of the RAV4, if it was to test certain things. But, they had an agreement. It's well documented. It's well explained in her recently filed brief what the nature of the agreement was for testing. If the Court of Appeals says we're sending this back for an evidentiary hearing, Kathleen could pursue either by stipulation with the state again, hey, I really think these things are going to narrow the issues. Why don't we go ahead and finish what we agreed to, let the court know that we're doing this, and get them to sign an order that that's okay. I think for sure if she's if it's sent back for evidentiary hearing on certain issues, I think she's going to start with that and trying to get that moving forward. If the issues that she's given an evidentiary hearing on just don't pertain to that, that's going to be difficult. But right now, and at the appeals level, they're stuck with what's in the record now. But one of the things she's arguing on appeal is that the court should have withdrawn that opinion and let the testing go forward. And she says that was an error. And they could just rule on that and say, we agree with that, let the other testing go forward. It's not necessary to consider any of these other issues right now.
Travis, in your opinion, if Kathleen is granted, or if Steven is granted the ability to have a new trial, do you think the state will go forward with that, or do you think they'll just let him go free?
That's an excellent question. With what we know right now, I would say that they would for sure retry it, because they've got Steven's DNA in the RAV4. And there's no explanation for that other than he was involved in the murder, or number two, it was planted there. And if they don't retry it, it's almost like they're acquiescing that they have knowledge that it's been planted. Now, if it turns out that there's dead bang evidence that one of these other possible suspects that get tossed around planted that evidence, and it's not somebody from law enforcement, they'd jump all over that, because that seriously hurts the value of any civil case he would have.
Right,
but
absolutely.
Man, we are just so sorry, Steven. We just never would have thought in our wildest imagination that, I'm just going to say, someone else on that property would have done that to you. We're really, really sorry. You've been wronged, and we hope you get what you deserve. Or so they have that out. And so then what they're left with is the thing on the RAV with Andy Colburn, and they could still try and pursue that.
I'm still of the opinion that Steven's blood in the RAV came from that blood vial. I'm not convinced that it didn't. I don't believe the FBI's test was valid. And eventually I do want to have someone on the podcast to talk about that, to explain that, because I'm pretty convinced that it was not proven to not be from the blood vial. I think that blood vial is still in play.
There are a lot of people that agree with you on that. And I would say I don't have enough technical knowledge about it, although I did talk to a lady on the phone a few times. I think you all know her. She's a chemist at a very large chemical company and has a lot of familiarity with EDTA and EDTA testing. And in those conversations, she laid out a lot of information that I'm not convinced that it wasn't the original blood vial either. A lot of the stuff on the blood vial was explained, and there's no question in my mind that's what they had at the time. That's what they should have been going with. And then I'm sure part of the 80 things was, if not more than one, is all of a sudden, we can't test it. And then, we might be able to test it, but it would take 6 months for us to be able to test it. And then the next thing you know, when there's not going to be a continuance, it's, I think we can test it.
Yeah, we've developed this new test.
Yeah.
Just for you.
Just for you. And guess what it shows? So that's
I don't buy it.
Yeah.
I'm not actually convinced that it's been proven that the blood that we see in the RAV is actually Steven, because what's been tested are swabs of blood that the state says came from those spots of blood that we see in the RAV, but that's also what they said about the hood latch swab. And I am also convinced that that hood latch swab never touched the RAV. So if they were going to switch that one, why wouldn't they submit swabs of Steven's blood that came from, I don't know, his other car that they had, or the bathroom, or anywhere else? They should have pictures of blood and said these swabs came from those places. But I don't believe you, because I don't believe them about the hood latch. So that's why I want her to test the RAV, because she can have somebody independent go and test it and say, this is what I found.
Right. And unfortunately, and you know, what's frustrating to a lot of people in the case, and it's frustrating to me at times, is all I can do is explain the legal process and where it is and why things are significant in terms of the legal process, why things are insignificant or of no meaning in the legal process. For example, whether or not a victim of a crime is dead or not. You know, that in this particular case, it has just no legal significance. And whether there might be more than one vehicle involved, for example, why that has no legal significance. And so, yeah, a lot of people get frustrated about why there are things that, from a logical point of view, are extremely problematic. And a number of the 80 things may fit in that category, but number 35 is squarely within legal significance. It has huge legal significance. I knew it when I saw it back last December and started working on it with the team. I knew it potentially had huge legal significance. But why this is frustrating is you don't get to start over. This doctrine of finality, it flips the burdens. And so from the legal perspective, you're trying to find a constitutional violation to get you to a new trial, to where you do get to start over with all of these things. And you can question. Everything could be questioned by Zellner in the retrial. But on appeal, there's a presumption that the jury got it right. And unless you can show one of these constitutional violations, you're stuck and you don't get to start over. And that's why she's really working super hard to find a constitutional violation under Brady or IAC, or when she became aware that these bones were returned last December, she asked the court to put the appeal on hold until the bones issue could be resolved. And that's exactly where we're at.
So we're coming up on time. Travis, do you have any final thoughts you want to share? I mean, that was a really good final thought that you...
Well, one last final thought is that this thing in December, you know, all this process, I wanted to show people that they could do this stuff on their own. And I've been blessed to be associated with people like Fen and Julie and Allie and many, many, many others who really go in, look at the documents, look at the facts, and hopefully I've been able to show folks that you don't need a law degree, you don't need a scientific degree behind your name to look into these things. And if you have multiple people and you work in a team effort and you utilize people's strengths and do a collective job on this evidence, you can make a difference. And we got real lucky with the bones. They ended up being a major aspect of this appeal. But you look at Julie's website, workwithkz.com. Initially, Julie would run these things by me very quickly, say, does this sound right? And Julie quickly learned, I hope, that she is perfectly competent to look at the procedure, determine how many days somebody has to file a response, what the next step is, to be able to summarize and encapsulate what the gist of the pleading or document on file is, and has got this wonderful site that if anybody wants to know what's going on with that appeal, you just go to that site. So hopefully I've helped her feel empowered to do that. I'm hoping that I've let people feel empowered that they can look at things and question them reasonably, and you can make a difference. What are the odds of that happening on the bones? You know, I couldn't believe it when I saw it, but what I wanted to do is set an example of how you pursue these things and that you verify them and that you double verify them and look where we are. But it can only do good for people to dig into the case, look at the documents, and reach their own conclusions. And that's kind of what I set out to do when I first got in it. I saw a lot of people struggling with meshing the facts and the documents and all the things that have been researched with the legal aspects of the case. And Julie's last question reminded me that the legal process isn't entirely consistent with the fact-finding process. And I know that's frustrating for a lot of people, but I plan to continue where I'm asked to try and educate people on the legal process and why things are significant or not significant in the legal process and where things can go. And, you know, that hopefully will end up with a resolution on behalf of Brendan and Steven that everyone can consider justice. And as you said at the top of the program, Fen, in your introduction, if there's justice for Brendan and Steven, then there's also going to be final justice for Teresa. And I'm glad you mentioned that. That should be on the forefront of everyone's minds. But, you know, we haven't even talked about the total injustice that Brendan received at the hands of his first court-appointed attorney and the investigator that is attorney hired. I mean,
oh yeah, we covered that pretty well in the last episode with
Yes,
Linda Kay listening. So
don't even get me started on that.
To give a listen to episode 8 if you haven't had a chance to listen to it yet. We do talk a lot about Kaczynski and Michael O'Kelly. So thanks again for being with us, Travis. It was really great.
Well, thank you for having me. I really enjoyed it, and I've really enjoyed all of the episodes. Hopefully this won't detract from the quality of the great guests you've had on previous to me, but I really enjoyed being here, and I really genuinely like the work that you all have done in the previous episodes. I think it's really good stuff.
Thank you, Travis.
Thank you.
So that'll wrap it up for this episode of 80 More Things. If you have a topic you want us to cover, or if you'd like to be a guest on a future episode of this podcast, visit our website at 80morethings.com and let us know what you want to talk about. While you're there, check out some of the links I've posted for the Center on the Wrongful Convictions of Youth, the Innocence Project, workwithkz.com, and bringbrendanhome.org. There is also still a petition to pass the Brendan Dassey Juvenile Interrogation and Protection Law, which is really important. I'm also working on posting all of the 80 days of 80 More Things on the website. There are lots of links to more information about the case. Don't forget to check out Stacy Seabrook on YouTube. Come get involved and let's see if we can find some actual justice for Teresa. The person responsible for her death is still out there. Thanks again, Travis.
Thank you, Travis.
Thanks for having me.
Until next time, take care.
So let's keep talking about Avery. Yeah, let's keep talking till he's set free. Oh, you just listen, I think you'll see why it matters.